We'll hear from the appellant when you're ready.
May it please the court. My name is Michael Davis with Legal Aid of East Tennessee, and I'm here for the appellant, Stacie Smith, and from the Knox Bar. And I would like to reserve 3 minutes for rebuttal.
3 minutes, that'll be fine.
Thank you, Your Honor. We're here today on various issues stemming from this landlord-tenant case, including the recently filed motions to strike and to dismiss, both of which we maintain that this court should grant. However, I would like to begin at the heart of what this appeal is about. This case is about the trial court abuse of discretion by straying beyond the applicable legal standards of what a landlord's duty of care is in reaching an unreasonable decision and basing that decision on an erroneous assessment of the facts and the evidence. We ask this court to affirm the habitability standards in Tennessee under its Uniform Residential Landlord-Tenant Act and the standards of the landlord's responsibility to make essential service repairs in a timely fashion. This is an issue that is so far-reaching for thousands of our most vulnerable Tennesseans that it is hard to overstate the importance as more and more people are renters and facing more and more difficult circumstances in finding affordable housing. For example, the appellant, Stacie Smith, is a single mother raising a 12-year-old son. She is disabled and receives SSI as her chief income at about $900 a month, qualifying her as indigent. Nearly 2 years ago, on May 9th, Stacie Smith was taking a bath in the 2-bedroom, 1-bathroom home that she rented at 4301 North Broadway that she rented from Gary Meek since January of 2023. As Miss Smith sat in the bathtub, brown, raw sewage bubbled up from the tub drain, beginning an ordeal that lasted 26 days of little to no functioning plumbing in this house that Miss Smith never asked for, never caused, and never expected to be discussing in this court here today. She endured a situation that far too many people like her do when faced with an urgent repair in the subprime rental market, where you're at the mercy of your landlord to promptly and reasonably make a repair or be forced to risk hardship, possible eviction, or initiate legal proceedings just to initiate legal action if the landlord does not comply with the statute or his obligations. She never expected the landlord to ignore her calls for help for 10 days, only to not respond with any meaningful help only respond with any meaningful help after being taken to court and admonished by the same court to comply with the law. She never expected to have to try to pay for her own plumber out of pocket and wait nearly a month without reliable plumbing before the landlord sent qualified professional plumbers to remedy the problem. She never expected the landlord to tell her, literally after weeks of no functioning toilet, that she should have just defecated into bags. And I'll advise the court, defecate is not the language that the landlord used. She never expected her and her son having to ask permission from neighboring businesses to use their bathrooms, to delay hours to toilet overnight, to endure the sickness and nausea caused by this and the unsanitary condition inside the house with the sewage collecting in the basement. Or most embarrassingly, to have to use the yard of this house to toilet when it simply wasn't working for days on end, which is located just feet away from Broadway, one of Knoxville's busiest thoroughfares. She never expected that the trial court, after hearing the evidence, would hold that this landlord did everything that he could and what a reasonable person would do to alleviate the issues, while allowing these conditions to continue. In a case that hinged on dates, such as the time from the tenant's initial phone notice on May 9th, or until the landlord's first maintenance response on May 19th, or the recurrence of the failure on May 21st, until the landlord finally sent a professional plumber to remedy the problem on May 31st and June 5th. She also never expected the lower court to say that the dates themselves are not significant as to the determination of the issues presented. She also never expected the court, in assessing and weighing the testimonial evidence at trial, to say that the tenant was no better at remembering the dates than Mr. Meek, except that she knew approximately in which month the issues took place. The very sentence itself points to the opposite conclusion from that of the courts. In a case that hinges on days, getting the month approximately right would be an extremely poor standard for accuracy. The truth of the matter is that the landlord could not even remember what season the crucial dates happened in, stating in his testimony that he thought that these issues happened in February, when they actually happened in May of that year. While it's true that Ms. Smith may not have recalled the exact dates at every occasion, she knew the dates when she notified the landlord to within a day or two, and testified consistently and cogently about the sequence of events. This is evident throughout the transcript of the testimony, especially when comparing the landlord's testimony to that of the tenant. What Ms. Smith also remembered correctly and testified to was feeling ignored and treated like an animal through this process, having to suffer through deplorable conditions of raw sewage piling up in the basement for weeks, the toilet overflowing into the bathroom, into the hallway for weeks, having to cook meals outside due to the stench inside the house being so overbearing, and being unable to afford repairs on her own, having already spent $750 on her own plumber toward it, and being unable to afford hotel rooms on top of her obligation to pay. To turn to some of the case law that's applicable in this case, we'll first start with the Arzens-Arn course and apply its findings and rulings there. Arzens-Arn v. Johnstown Properties, which is a case out of this very court, it's very similar to the instant case. It dealt with the landlord's timely and adequate response, highlighting the importance of dates and a time frame. In that case, on June 26, 1989, a roof replacement began over the tenant's building. On the next day, the 27th, heavy rains began, and the tenant's apartment began leaking through the ceiling. On that day, the tenant informed the landlord of the problem. Not until July 1st, after repetitive requests, did the landlord send a worker who only punched a hole in the drywall of the ceiling, allowing some rainwater to escape. The very next day, on July 2nd, the ceiling collapsed, injuring one of the tenants in the home. Here, the court in Arzens-Arn found that the landlord was negligent after inadequate response of only 6 days. Here, the landlord did not respond meaningfully for 10 days on 2 separate occasions. Most importantly, turning to the time of May 21st to May 31st, the landlord was aware of the problem, had already sent unqualified tenants who were handymen to try to tackle the problem, and yet it persisted. He kept sending them back over and over again, knowing that they were not successful. Also during this time, the landlord claims that he contacted another company, the Plumbing Authority, but also testified, and according to the testimony of his own witness, that they would not respond when called multiple times. They didn't show up for appointments that they had scheduled. He called them back. Days passed. 10 days passed from May 21st to May 31st with Ms. Smith living in these deplorable conditions. The only other offer to help was paying $240 to her to secure hotel rooms. That would add up at the going rate to about 3 days. 3 days out of 10 still leaves 7 of living in these kinds of conditions. And that's far beyond the standard that we see in Arzens-Arn. Turning to the abuse of discretion. Discretionary decisions must take in the applicable law and relevant facts. An abuse of discretion occurs when the court strays beyond those applicable facts, and fails to properly consider factors customarily used to guide a particular discretionary decision. Here, if the trial court was applying the correct standards, as in Arzens-Arn and other cases like Quimby and Sneed, then it could not have reasonably arrived at the conclusion that the landlord met his duty of care with his response. At least 10 days, or more accurately, 26 days from May 9th to June 5th, when this ordeal finally ended and the plumbing was finally cleared, was far beyond the 6 days that the court found constituted liability in Arzens-Arn. repetitively sending unqualified personnel to fix the problem after he knew of the severity of the problem, after he knew that those handymen were not effective at clearing the problem, is not meeting the duty of care that's set forth in Quimby. The landlord is responsible also for the results of those ineffective repairs, such as the landlord in the Sneed case. The Tennessee Supreme Court has held that a court abuses its discretion when it causes an injustice to the party by applying an incorrect legal standard, reaching an illogical or unreasonable decision, or basing its decision on a clearly erroneous assessment of the evidence. It's illogical here to say that the dates essentially don't matter when they are just as crucial to assessing the facts as the issues were in the Arzen-Zarin case. That case turned on the facts. This case is no different, or turned on the dates. This case is no different. Erroneous assessment of evidence, its erroneous assessment of evidence to conclude that the tenant was no better in remembering dates than the landlord was. When all throughout the testimony, the landlord could not even place these events in the correct month, let alone remember the daily occurrences of his business or the sequence of events. Perhaps most importantly, it's an erroneous assessment to conclude that the tenant somehow caused this, when the house is nearly 100 years old, had never had the cast iron plumbing replaced, when she reported the sewage failure by phone on May 9th through May 18th, paid for her own plumber around May 11th and 13th, and notified the landlord in writing on May 19th and May 21st, got a lawyer and took him to court on May 24th, and then on May 31st and June 5th, Roto-Rooter determines that the main cause of this issue is that the pipe is collapsed and roots are growing into the pipe, which would catch, by quote of their own technician, anything that was coming into the pipe. It wasn't the landlord that did everything that he could. By nearly every bit of the evidence put forth in this case, it was the tenant that did everything that she could. It shouldn't take 2 injunctions over 26 days to fix a plumbing problem. Thank you. I'll reserve the rest of my time.
Boy, you said she paid for her own plumber on May the 11th?
Yes, around that time, she contacted a gentleman named Ben Sweet, who was acquaintance of her, who did handyman work as well, and paid him $500 the first time and $250 the second time. She testified to that at trial.
Did he correct the problem?
No, he didn't. Well, I think it was cleared up for maybe a day or two. That's why she had to call him back. There were 2 separate occasions where she called him in to attempt to fix the plumbing. But as the facts show, this issue was so severe that it needed a more professional type of equipment and expertise to clear this.
Was her plumber that she called a professional, or was he what we call a shade tree plumber also?
I believe he ran a contracting company. I don't think he was a licensed plumber, had some experience with it, had some equipment, but not like a company like the Plumbing Authority or Roto-Rooter.
Okay.
Thank you. You have your time for rebuttal.
Thank you.
We'll hear from the appellee.
If it pleases the court, I'm Craig Garrett, Blount County, represent the appellee, Mr. Meek. As indicated by counsel, he's also filed a motion to dismiss our appeal and also a motion to strike a portion of my brief. He didn't address it in his argument. I was going to start with that, but I'll come back to that in the end. I do want to address that briefly. But I want to talk about the position that the appellee is taking in this appeal. What happened here is we had a contested trial, and there were 3 witnesses. There was the plaintiff, the tenant, and then the landlord, and then a licensed contractor that did contract work for Mr. Meek from time to time. And their testimony was disputed, and it was oral. And the trial court started out its ruling after it took the case under advisement for about a month and made a very specific finding about credibility and found very specifically that the plaintiff was not a credible witness, that not only in what she said she wasn't credible, but in the way she said it. And he made that comment, and that's exactly the case. And because of that, and because of the things she said, for example, she would do things like she would just say something on direct, but then when you would question her about it on cross, she'd just readily admit the opposite. Things like that. For example, she said that the waste in the basement was never cleaned up. Well, when I asked her about that on direct, she said she never went down there and checked, but she did see Mr. Buckley Kidd, the contractor, and another individual with hazmat suits go down there and carry stuff out, and admitted that her boyfriend went down there and looked, it was clean. But she just did that over and over. She was an incredibly uncredible witness. And so the things that the plaintiff, the appellate, wants to take as true were actually disputed. For example, they claimed that this 10 days and this first notice, the tenant claimed that she first notified Mr. Meek by calling his office and talking to his assistant or leaving a voicemail, I can't remember, on the 9th, and said there was a plumbing problem. Mr. Meek specifically denied, I never received that message. If I had, I would have sent somebody immediately. That was disputed. It was decided against the plaintiff. The judge didn't believe her. And then she claimed, and the gentleman that she sent to call to come fix the plumbing,
Sorry, let me ask you about that. I found that interesting. He didn't testify she didn't call in. He just testified he didn't get the message.
Didn't get the message, didn't receive the message.
How does that proof that she didn't call in and leave it with his assistant?
Well, but it's proof that he didn't receive it.
It's proof he didn't receive it. It's
Right.
not proof.
And
It wasn't proof that she didn't call in.
Right, and didn't ignore it, correct.
I understand. Okay.
And the next thing that's questioned about her testimony is she claimed then, even though and she put a different date in her pleadings than she stated she said that she called on the 10th instead of the 9th, but as the judge says, the crucial dates were all evidenced in this case by documents. In other words, when she actually did send an email, and when and the receipts and so forth of Roto-Rooter, the dates were not in dispute. Mr. Meek's 88 years old and couldn't remember exactly what month this took place in when they called him as their first witness, as an adverse witness. But what she did then, after she said she called Mr. Meek, didn't say she called back, didn't say she followed up, didn't send him anything in writing. She claimed in the middle of the night on May 11th, she called her under-the-table boss. That's the way she described him. I called my under-the-table boss, Mr. Sweet, to come in the middle of the night on May 11th to unstop my toilet. So my question was, well, why did you wait till the middle of the night on May 11th? And then I also questioned her about, what do you mean under the table boss? These are her words, right out of her mouth. She says, well, I'm on SSI disability, and I work for Mr. Sweet under the table, and he pays me so I can collect my disability. And then she claimed that she had an office for Mr. Sweet in her house, and claimed, which we disputed, she claimed she paid him $500 in cash, didn't have him come testify. But he supposedly came in the middle of the night, even though her plumbing had been messed up since May 9th on the 11th and unclogged it. My client testified the first that he was aware of the plumbing was on May 19th, and immediately that he received a written communication and immediately sent someone out there that afternoon. And what they found was a toilet that was not only stopped up, but it was filled to the brim with waste and debris. And Mr. Buckley Kidd is who he sent. Now, Mr. Kidd, they say he's a Jake. He's a licensed contractor that does home improvements. He's also a tenant of Mr. Meek's, lives next door to Miss Smith. But he couldn't do anything with it that night. The next day, he goes back with a Richard Watts, he works for Help Plumbing, but does some work for Mr. Meek on the side. They got the problem fixed, had to take that nasty toilet out. Mr. Watts went downstairs in this house and put a clean-out plug, and that fixed the problem until the 19th when they sent an email. And our clients did everything, or Mr. Meek and the individuals that he had did everything that was reasonable, and that's what the court found in this case. And what happened in the case is the court just didn't believe the testimony of the plaintiff and made that clear in the beginning of the court's ruling. He found that she to be an uncredible witness, not only in what she said, but how she said it. She found Mr. Meek and Mr. Kidd to be credible witnesses. And ultimately, when the plumbing authority wouldn't come as quickly as Mr. Meek wanted him to, and he had got Roto-Rooter to come out, again, when they came out, the toilet had again been used to the point that it was full. And plumbing problems, generally plumbing problems are not that complicated. Generally, you start out trying to plunge. If plunging doesn't work, you start out with a snake. If a snake doesn't work, you progress on. But Roto-Rooter came out, and they ran a commercial type snake, and when they did, a rag was found. Somebody had put a rag down the toilet. And the testimony, which the court found in its finding as credible, was not only was rags put in, but paper towels were put into the commode. And the court found specifically that the tenant had contributed to that. So this case, as we noted in our brief, it is a case that is very much comes by the rules of appellate procedure. It comes to this court with a presumption of correctness, but it also is a case that is decided on credibility of witnesses. And the cases which we've cited in our brief, that when the trial court makes a decision that hinges on witness credibility, then it will not be reversed unless other than oral testimony of witnesses, which is all we have here, there is found in the record clear, concrete, and convincing evidence to the contrary. And that's what the plaintiff wants to continue to ignore in this case. This case was decided on the basis of disputed proof, and the case was decided based on the oral testimony without anything to back it up. I would note the plaintiff didn't bring in this Mr. Sweet, her under-the-table boss, to verify that he received $600. What they failed to mention is while this period of time was involved, that the court's this 10-day period from May 21st to May 31st, the parties were in court. They were in court on 2 occasions. During that time, Mr. Meek paid to Ms. Smith money for her to go to a motel, and also she failed. Her rent was $1,200 per month. For the month of June, she only paid $600. So she had an extra $600 in her rent. She had $240 from Mr. Meek to obtain other accommodations while this problem was being addressed. And the court found that Mr. Meek, in his actions, through calling Mr. Kidd, sending him out there multiple times, Mr. Watts, and then Roto-Rooter, was credible and was reasonable in what he did. That is the legal standard for this, and the legal standard, and the court recited that in its findings. The lease put a requirement on the tenant to keep the premises in proper cleanliness and not do anything to damage the premises. The statute cited 66-28-401 is the tenant's obligation, 66-28-304.
Yeah, was there any testimony that anyone else had access to the bathroom facilities other than the tenant?
The tenant and her son, and then she had a live-in boyfriend that the lease specifically prohibited. We didn't make a big deal about it, but the court did note that she was using it, her guests were using it, her boyfriend was using it, and I don't know if anyone else was or not, but it's undisputed that on 2 occasions during this time, they continued to use the toilet after it was stopped up to the point that it was completely full. And when the Roto-Rooter was there, Mr. Kidd was there, it had not only feces and waste in it, but it had paper towels, and it also had, once they cleaned it out, there was a rag down in the pipes. They suggested that the pipes were broken, but what Mr. Kidd testified that ultimately, after the Roto-Rooter fixed the problem, June 5th, it was fixed after that. But my client went ahead and paid Mr. Kidd to dig up the pipes in the yard, replace those, and when he dug them up, they weren't collapsed. The pipes weren't collapsed. And so the court found that part of the problem was the tenant's improper use of the facilities and the improper things that they put down the facilities. The bottom line is this is just a case that's decided on disputed oral testimony, and it's decided on credibility, and it's very difficult, if not impossible, to reverse that on appeal. So with that being said, there's a couple other issues that I want to address. And one is that the plaintiff claims that the court erred by not filing addressing their motion for summary judgment. And they made a misrepresentation in their brief that the trial court ignored the motion for summary judgment till the date of trial, and that I ignored it by not filing a response. And so they're asking this court to go back, even though we've had a contested trial, and now find that their undisputed material facts should have been admitted and they should have been granted judgment, when what happened is I got involved in this case after it was in circuit court, and it was when I got in it like the day before it was set for trial. Judge Melson had a conflict when I got in it because I had a prior representation of Judge Melson. He transferred to Judge Ayler, who set it for December the 8th. We jointly asked the court to reset that trial date, and when Judge Ayler reset it, he said, I'm going to reset it, but and penciled in the order, it won't be reset again. And so with that being said, we had our trial date. They filed a motion for summary judgment 35 days before that. Unbeknownst to me, the judge's legal assistant reached out to counsel and said, the judge is not going to docket that and hear your motion. There's not enough time for the court to address that with the trial date set. I didn't know that until Mr. Davis sent me an email. I was working on a response. When he sent me that email, I sent back and said, are you sure? He said, yeah, they told me that we're not going to hear it. So I didn't file a response. In their brief in this court, it made it sound like I ignored that, and they specifically said that the trial judge was silent on the issue until the day of trial. The day of trial, he brought it up, and the court just said, no, there wasn't enough time. And what it was, the court has a policy that a motion for summary judgment needs to be of record for 45 days. What would have happened is if we would have heard motion for summary judgment, the trial would have had to be continued, and the judge exercised his discretion and didn't hear it. They're now claiming that was error. We know the case had disputed facts. Summary judgment would have been successful, so that issue is meritless. They also claim that the appeal should be dismissed for lack of jurisdiction, because now they're claiming for the first time, not in front of the trial court or not in their initial brief and their issues, but they're now claiming the original judgment from the General Sessions Court was not a final judgment. So when the appeal went up to circuit court was without jurisdiction. And so now they've raised in a motion to dismiss, which they're saying they want you to dismiss an appeal, but they also want you to vacate the trial court's judgment while you do that. So I see weekly where this court dismisses people's appellate's appeals when a trial court's order is not final. But what they're saying is the General Sessions judgment is not final. Well, in fact, it was final. It taxed court cost. It granted every bit of relief they asked for. It granted damages for every day that repairs weren't made. So that again, the motion to dismiss is something that was disingenuous and not even raised till after we raised the frivolity of their appeal in our response. So their motion to dismiss is not well taken. A motion to strike my brief because in the argument section they say that we did not cite to the record in some of the argument. Well, it was our opinion that their statement of the case and statement of the facts were insufficient, so we made an extensive statement of the case and statement of the facts in our brief, with all of it with citations to the record. And so when I repeated some of those things in argument, I didn't cite to the record again. So our response brief, there's no basis for striking that. The bottom line on this appeal is that that this is a case that was decided on disputed facts. You can't come to the Court of Appeals and ask you judges to second guess a trial judge when they make those kind of findings. There's just case after case of that. So we do think that this appeal is frivolous and it should be dismissed.
Thank you. Here from the appellant, rebuttal. Counsel, let me ask you a question. If you were right, if you're correct, and the trial court erred in not hearing your summary judgment motion, how were you harmed?
We were harmed
In other words, if it's error, how is it harmful error?
in that case with no response from the other side, and because the court issued no official ruling on it, then by many instances of case law, there should have been the plaintiff at that point, Ms. Smith, would have been entitled to her statement of facts being adopted. Therefore, the whole trial would have proceeded differently had there been one.
But the whole reason he didn't file a response is because he was told by you guys not to.
And to properly characterize that, Your Honor, I inquired about the setting of the motion for summary judgment hearing of the court. They responded back that the court was not going to set it, that it was not timely. Now, if you read the rules, even if you add the mailbox rule to it, there's a 33-day period before any hearing in which someone can file a motion for summary judgment. I filed this 36 days before the trial. There is no rule that says that there has to be this enlargement of 45 days. If that's the court's policy, it should be written down. There are no rules at the circuit court level that state that policy. No one would be aware of this. So,
but you were told that the trial court wasn't going to hear the motion for summary judgment.
Yes, Your Honor, and I immediately
and you immediately
notified
passed that information on.
Yeah, notified counsel that that's what I was told.
I understand that, but the question is, he's told from you that the judge is not hearing your motion for summary judgment, so what is there to file a response to?
Well, Your Honor,
by the defendant.
I expected, just like I'm sure Mr. Garrett did, that the court would issue some ruling on this, but it didn't happen. There was no ruling on that is not going to be docketed, nothing in writing, no dismissal of it whatsoever. Frankly, it's not opposing counsel's job to cover all the bases, to confirm, to ask the court to put it into writing, or supply a brief just in case a reply to that would be necessary so that this issue didn't happen.
But the trial court told you all it's not hearing the motion.
Yes, Your Honor, it was over the phone. I expected there to be some more formality to that. But the court itself, in terms of any official response, was silent.
Okay. I'm sorry, go ahead.
Quickly, Your Honor, on the credibility issue, the question to ask would be, why would someone wait to notify their landlord that their plumbing had completely failed in this kind of an issue where sewage was literally coming up from a tub drain? Even the worst liar in the world would not wait to tell their landlord and then try to cover it up later, living with that for 10 days saying, no, I called them on May 9th when it didn't actually happen. And Your Honor pointed out correctly that the testimony at trial is not that she didn't call, it's that the landlord didn't get the message. That's still his responsibility. If his business is not functioning correctly, then maybe he should not be in the landlord business, because it is an important business. People live in these houses. They get sick in these houses when these things are not taken care of. This has to be a higher standard in Tennessee for some of our most vulnerable Tennesseans that are in this substandard rental market, just like my client.
Thank you.
Thank you.
We appreciate both sides' arguments and briefs on this. We would recess court till 1:30 this afternoon.
All right.